To notice, Mr. Devan, Mr. Reddy.
I'm grateful. Manoj, may I request a status quo? At least I don't want.
You should notice returnable loan.
I'm grateful.
3rd August. Status quo obtaining as on date shall be maintained in all respects.
Grateful, Your Honor.
Grateful.
Question. $64.
May I please, Manoj?
Yes.
Well, these are 3 petitions. One is by SIDCO, which is the Developing Agency of State of Maharashtra. Second is the KIDC, which is the agency through which the contract was carried out, funded by SIDCO. And third is the State of Maharashtra, Manoj.
Yes.
Well, this is one matter which I am reasonably confident will shock the conscience of the court. I'll start with what is wrong with the 34 per se. It is an award where 3:2 findings are there. So it's a tribunal of 5, 3 and 2.
Yes.
On the face of it, 34 to requirement of 34 on a perversity and illegal patent illegality. Page 313, which is the part of the award, Manoj. On the face of it.
313.
Before I come. 313, Manoj.
Yes.
On the middle of this page, Manoj, a particular clause is given, which reads clause 70.3, because this is one of the big bone of contention, that whose responsibility is to secure the forest clearance. Yes. The award very clearly says, the contract very clearly says 70.3, responsibility of the contractor shall have a responsibility toward the final clearance as mentioned in the all steps. The work of the dam shall not be started unless at least the principal clearance of forest land is obtained. The corporation shall extend us necessary help as and when required to the contractor. On this clause, what the tribunal says is interesting, Manoj. As discussed earlier, applying for and granting forest clearance was a matter which was within the exclusive domain of the officers of a different department of the state government and the central government respectively. It is relevant to note here that the contract is a printed document containing several errors and inaccuracies. It is an old stereotype contract containing several clauses which are wholly inapplicable. For instance, then it goes on narrating few clauses. On next page.
Not only that, they specifically say that.
It doesn't end there. Interestingly, it doesn't end there. Page 314, last 4 lines on this. This contract, yes. Last 4 lines, this will render the provision of section 73 of the Indian Contract Act completely nugatory. We are only mentioning a few clauses which show a typical case of unequal bargain power between the contracting parties when printed documents running into hundreds of pages are signed without verifying the same. In an appropriate case, such clauses may be held to be in teeth of the provisions of section 16 or 19 of the Indian Contract Act. It is not necessary to dilate on this subject any further. Suffice is to say the complete non-application of mind and casual journal observations are made while issuing a notice without appreciating the ground realities. So they says what you have written in the contract is bad. Don't look at these contracts. Under the Environment Act and the other regulatory scheme, the state executive, on the face of it, a clause and a contract are completely outside the contract, Malas. That's on the face of it. Second part, which is extremely important, Malas. In this case, if my lords can kindly, the very big, this was a project, Malas, for potable water, drinking water in a particular area was to be set up. SIDCO was the agency which was supposed to fund. KIDC was supposed to appoint a contractor, and a contractor was appointed, Malas. Initially, the value of contract was 350 crores, which was elevated to a level of some 1200 crores. Corruption charges were found. The government issued GR in this case, and that GR is available at page. Malas, I have
the GR.
Government resolution, Malas.
Government resolution.
Yes. The state issues those resolutions, and this is the GR is available at Malas, additional paper book I have filed, Malaz. I'm sorry, I filed later. It's not part of this. If my lords can please call that paper book for permission to file the additional documents. Malaz, this is
IA is 150454. That one?
yeah, Malaz, this is running into 219 pages.
Milord, may I come in, Milord? I don't have these additional documents.
Malaz,
Allow me to, Milord, have a look. I don't have them.
This IA is not served on you, Mr. Rodgi.
No, Milord, I don't
Malaz,
have
this
it,
has
Milord.
been, it's been served, Malaz, to everyone, and then it has been filed.
Well, Mr. Rodgi,
There are
doesn't
three
have it,
connected
Mr.
matters,
Balbir.
Milord.
13th May, Malaz.
1 second, sir, 1 second.
13th
There are three
May.
connected matters, Milord. He has filed some documents in one. Impugned order is common. I want to have a look. Your Lordship may call it on Friday.
Malaz,
This IA is filed. This IA is filed in Sidco's matter only.
Malad, Sidco's
yes, Malaz,
matter is actually irrelevant.
diary number one. Diary number
Malad, can I say one
136
thing?
of
No, Milord, I want
2026.
to have a look.
Kindly
We
just
are in a companion matter. Impugned
Malaz,
order is same. Please allow us to have a look and call it on Friday.
Malaz,
Milord.
today,
That's all I'm
Malaz,
saying.
My lord,
let me
Mr.
show something
Balbir
else,
Singh,
Malaz.
let me point out one thing, please. Sidco's
Malaz,
matter
Mr.
actually
Sundaram,
is
I'm
the
for the
most
timely
irrelevant.
notices. If you
Just
really
1
want
minute.
notice to be
It is the
issued,
most
notice can be
irrelevant
issued.
matter because Sidco, the award is only 15 lakhs.
But it's
Sidco is
not a
not
question
really
of the
the
award.
aggrieved
It's,
party.
is the
It's KSIDC which is the aggrieved party,
Mr.
not
Sundaram,
Sidco.
certainly you are not brief. You
Sidco,
have
there's
brought
no
brief.
privity.
You have not been.
Anyway,
You have not been
that's
shown
all
your writ
right.
petition. Kindly allow me to.
I'm appearing in
complete.
Sidco, I'll deal with it.
Malaz, I don't need to say anything more. I think
My
the
objection is
very
far more.
opposition,
There's
if
been
they
a
don't want
blatant
to,
lie in the SLP, I'll
let them
show that.
reply. Let them reply, Malaz. I have no difficulty. But
I'm only saying, please allow me to have a
Let me-
look, Milord. I have no
Malad,
idea what he's talking about.
Malad, all documents in
Malad,
Mr. Rodgi's
can I make a suggestion?
SLP are there.
Will you have
It's
it
only the
tomorrow
Sidco
morning?
because
We can all be present in
Malad,
your court.
Malad,
Will you have it
if
tomorrow
Mr.
morning?
Sundaram
We can
doesn't
give
want,
the documents.
Malad,
We can be present in your
let me
court
sh-
tomorrow. That's all I'll ask.
Malad, let me show beside the GR for a minute, Malad. What the tribunal says is that the GR is bad, it's null and void.
Has any
and
execution
226
petition been filed
This has
yet?
been done, Malad.
Have
I'm
they
saying,
filed
Milord, allow me
any
to have a look.
execution petition?
Why is my friend going
Malad,
on?
Mr.
We'll have it
Rodgi's
any other day.
paper book already has
There's
got
no great
this.
urgency.
I'll give the number. I'll give Mr. Rodgi's paper book number. Malad, just give me a minute. I'll give that number.
Mr. Balbir, has any execution petition been filed?
Not yet, Malad.
Not
Not yet. We are seriously apprehending. But it's a case which requires, with all humility, requires
I don't think
consideration.
so, Milord. I have
Very
several
serious.
submissions to make.
Mr. Rodgi, kindly allow
I have
me.
several
Mr.
submissions to make.
Once I
Mr.
complete.
Rodgi, the very fact that the arbitral tribunal was 3:2.
My lord, I have a
And the
3:2.
finding I've
It's not a
read.
unanimous
I have a
arbitral
different
award.
reason.
Therefore,
I say
that by
this
itself
SLP
perhaps
should be
is
dismissed with
reason enough.
strictures. My lord,
Apart from the fact that the 34 court sets aside the award and the 37 court
my lord,
restores
hear
it.
me for 1 minute,
At
please.
least there are debatable
My lord,
points.
No, my lord, just 1 minute. 1 minute.
My
They
lords
will
could
issue
see this
notice
book
and
of
hear
34
you.
minutes, a
My
well
lord has
written
missed the
order.
most important
It's
point.
at least
My lord,
a
I should
case
be heard,
which
my lord.
has already
should be
got a
heard for a
toehold
minute.
in the door.
My lord, please hear me for a minute.
Malad,
1
I have
minute.
shown the award.
More than 1 minute.
Can
Just
today
1
the
minute, Mr.
tribunal
Balbir.
say this?
1
That I have
minute.
not looked at the contract?
Please, I have a basic
Definitely not a
objection.
case for
This
being
SLP
shown the door at the
contains
threshold.
lies. This
So you can
SLP
file your
has to be
replies,
dismissed.
thereafter
My
we'll
lord,
consider.
sorry, my
That's
lord,
great.
please hear me.
Request
My
keep a
lord,
look
you
from
have
your
to hear
lordship.
me on this, please. My lord, this SLP has stated falsities. I want to show you. You have to dismiss it with pictures. I want to show you.
Please
straight
counter
away.
them. Please counter them.
There are
For
false
that also
Okay,
you
if you
need
can.
File a
to
reply.
file
No, my
your
lord.
counter, is it not? If you
Station.
file your reply and then you show us,
Yes.
then
I will show you on their
consider that
record.
then.
I'll show you on their record, my lord. They have made a false statement before your lordship.
Hateful
It's,
words.
I'm not
Why
even
don't you
saying
show it now
misleading.
itself then
I'll
if
show
you're
it
in a
now
position
itself.
to?
I'll show it now
Yes.
itself, your lordship.
Yes,
Please,
what
my
is the
lord,
false statement?
Yes, please, my lord, take very ground, the main ground, which my learned friend is assiduously missing now. It is at the main ground in the SLP. Please see page 90. I'm shocked that this has been done. Please
I
read
mean, too shocked.
NNN, OOO, and PPP. Please read these four with me. Is
Triple M.
Yes.
Yes.
It is further submitted that during the pendency of proceedings for the High Court, recorded parties were moving amicable terms of the broader MOU. Thereafter, the Principal Secretary directed rates and quantities. STAC is the highest technical body estimated under the Water Resources Development Department for evaluation of a major dam irrigation projects. However, however, the arbitral award does not reflect adequate consideration of SLLTAC findings, nor does it demonstrate meaningful engagement with conclusions. Relevance lies in the fact that a competent statutory technical mechanism had examined the very issues of rate determination and quantity. Absence of proper consideration of such evaluation bears directly on the question whether the award ignored. Now, non-consideration of vital expert material renders regard perverse within the meaning of 34(2)(a). My lord, this STAC was to decide disputes not with me, with SIDCO and KDIC during the 37 petition. It was never there before the section 37 appeal. It was not there. There was no STAC at the time of the arbitration, at the time of the 34. And yet this will say non-consideration of this STAC that did not exist. The STAC for the first time was to decide disputes between SIDCO and KTAC. That is two governmental bodies. It has nothing to do with private bodies. It has to do with governmental bodies. Disputes between SIDCO and STAC. And that was formed for the first time ever during pendency of the section 37 appeal. How then could this averment be made in 000 at page 91? It is ex facie false.
All they
I thought it was
participated.
recorded that the
False.
Everybody participated in that.
It is ex facie false.
Everybody
How can it-
participated. Mr. Sundram's client participated in it.
Now please see page F.
Well, I also want to say something.
Page F.
Kindly, Mr. Sundram, give me 1 minute. I want your lordship to see paragraph 40. This is an admission. This appeal cannot lie, belong against an admission. And to para 40.
Yes.
Para 40.
Yes.
The arbiter para 40, my lord, which is at page 32 of the second SLP.
Yes. Yes.
Probably.
Yes, Mr.
Yes. The arbitral tribunal awarded FA Enterprises total sum of 303 against KIDC. As regards claim 1 for the amount of RA bill, the arbitral tribunal awarded so much. That is on the basis of so much, as specifically admitted by KIDC in the reply to 31(6) applications and the written submissions. How is they filing an appeal, Lord? Number 1. Number 2, he mentioned about GRT. Kindly turn to para 56. Para 56. The single judge was completely wrong in para 56. The division bench records, my lord. The learned single judge has set aside the tribunal's finding that the GR, which is a government resolution. Government resolution issued under 25 was void. The single judge held that the tribunal did not have jurisdiction to consider validity of GR, which is fine. The single judge held that arbitral tribunal could determine notice validity of termination and not validity of GR. Single judge found so. Now see the next line. We find substance is Samir Chinoy, senior counsel, that the GR which was issued to a series of contracts did not constitute subordinate legislation, was only administrative direction. Validity of GR arisen incidentally, as they provided that the contract along with the number of irrigation can be terminated on merits and by taking action in the relevant clauses. Moreover, we find that the tribunal has not considered validity of GR in general, but only insofar as this is a contract. The finding of the tribunal as GR is concerned, but clearly severable, did not affect validity of the rest of the award. KITC purported to terminate the contract not on basis of GR, but on merits under 15(1). The termination, my lord, is at page 156. Have a look at 156. My lord, Mr. Balbir Singh is entering into an appellate forum. 37 is not an appellate forum.
I am making a submission. This is factually...
Second, please. Allow me to complete now.
Termination.
If you don't mind. My lord, turn to 156, my lord. This is the termination, my lord, which was held by the single judge to be a part of the GR. Now, my lord, this goes on, and then kindly turn to 157. On the top, after lapse of 7 years, you have not obtained the FC for which, my lord, wasteful expenditure. During investigation, severe strictures passed on general lapses and execution. This resulted in appointment of this matters under investigation. Subsequent review of charge sheets also. Now the next paragraph. Further with reference to the GR, the GM Maharashtra has ordered rescission of contract. So this is only an incidental submission. This is not the basis of the termination. The single judge held so.
No, that's the
Now, Milord, 1 minute.
but precisely the first
Mr.
para.
Parveer Singh,
Anti-corruption
please.
branch is
Now, Milord,
investigating KIDC officials.
1 second, please. It will go on investigating.
It's a matter of collusion.
1 second. Now, Milord, two technical submissions. Kindly turn to volume 2, page 726. 64.1. In 64.1.
64.
Yeah, let's turn to 720. There are two technical the contentions I'm raising. Kindly turn to 726. This is not 726. Is an application for certified copy, and there is a Supreme Court judgment now saying that this is no good. Turn to this, Milord. See paragraph 3. Because of Justice Chandran has, Milord.
Yeah.
Yes. Yeah, kindly, Milord, have a look at this. Just see paragraph 3, Lord.
Yes.
Because of urgency in the matter, petitioner could not get certified copy. Has he applied? Has he not applied? Nothing. And there is a judgment of the Supreme Court that when you apply, you have to file a copy of the receipt with the application. Number 1. Now turn back one
That's
page.
under appeals under enactments, Mr. Rodhi, not SLPs.
My lord, can I say this? There is
Even
so
in an SLP, Milord,
Any
you are
of
supposed to
we
file.
are inclined to entertain these special leave petitions, so you can file your responses. Thereafter, we'll.
Then ask them to deposit the amount.
Grateful.
basically a money decree.
Basically, Milord,
Basically a money
notice.
decree. 400
There's no
crores
execution.
is
don't want you
as well
not
as
to
on the
deposit
prayer
the amount.
performance.
400 crores is
Interim
due. Let
relief
them, my lord,
made
deposit.
therein.
Grateful.
We have issued notice on the prayer for
Grateful.
interim relief also
Very well,
because
Manoj.
we
Very
said that
well.
no
Great.
leaves are filed. So you can file your responses thereafter. We'll consider.
Great. Grateful.
My lord, we should notice on the prayer for stay, is it, my lord? I'm
Yes.
sorry, I couldn't hear you.
Notice on the SLP as well as SLPs as well as on the prayer made therein for interim relief.
Great. Grateful.
Lord.
Third August.
Grateful.
Item 65, Lordship, I have
65.
I am
This is a
seeking an
problem because now the other matter has been tagged with it. Trial court records are received so far as 65. Sorry, I'm not looking at
it is on matrimonial.
One moment.
transfer.
One moment.
Then 65, we
is
are obtaining for
the
respondent.
transfer pet.
Weeks. So we are seeking 4 weeks time to 5 counter.
Very
And may I request
Yes.
that it may be sent to mediation center at Supreme Court. There are possibly fair chances of amicable settlement if it is referred to mediation in the
Yes,
meanwhile.
counsel,
And we'll find.
petitioner's counsel. Are you
Lordship.
agreeable?
Yes, Lordship, mediation center.
Okay, that mediation order. Don't
Virtual-
file a counter before you go
Lordship.
for mediation, please.
Lordship.
If it fails, then you can file a counter.
Lordship.
Don't say anything at this stage.
Lordship. Lordship.
Appear before the mediator on May. Parties are at Ajmer and
And Bhopal.
is it?
Lordship.
So first
Either through one mode also.
appearance you'll do online.
Yes.
Lordship. Or we can come physically also.
All right. Then if you're playing physically during the break, it will be open mediation center. No, June. Oh. So mediation
Lordship
center will
will
be
be
right.
open virtual facility also.
All right. Appear first time online. Then I'll give a date before
Lordship.
the break itself. Then
Lordship.
28th May
Lordship.
at 11 a.m.
Lordship.
66, there's a problem because the trial court records are received, but 66.1 has been tagged and notice has not even been ordered yet.
Filed a reply to my bail application.
In 66.1,
It was
notice has not been ordered.
because your lordship, on Friday they had said that they'll file a reply. Now they filed a reply. Reply is on record now. We'll file an
66.1 filed in. यहाँ है
Lord, now I've been in custody for 13 years, 2 months, Lord, 3 months.
Your Lordships, the petitioner herein has been awarded life imprisonment. Serious sections are there.
Oh, it's here,
And,
it's here. 66.
Your Lordships, his conduct may also be seen.
Notice has not been ordered in this, though.
It was
66.1.
tagged, Lord. Your Lordship, that tagged it with the main matter.
You made a mention, perhaps.
That was for my IAM laws. Before that, the main matter was it was tagged.
Is coming for the first time.
First time. Because delay is also not condoned.
Lord, it was
He directed the matter to be tagged with this in the event defects were cured.
Yes, Lord.
So now the defects seem to have been cured, so it's only the delay which is yet to be condoned and notice is yet to be ordered.
On the IAM laws, Your Lordship, I had heard my eye on Friday laws, wherein I told
No, we only directed that the matter would be taken up.
No, they filed reply. They sought time to file.
This is the application for consideration that is on the date on which the main matters are directed.
Yes,
But in your matter, the notice has not yet been ordered yet. Without the notice being ordered, how will we consider your IA for
filed a
interim
reply
review?
to my IA and the main matter.
Very well, we'll issue notice now. Delay condoned in diary number. Delay in filing and refiling condoned. This is diary number 72675 of 2025. Notice, Mr. So-and-so, Mr. Aditya
I
Bharat
accept notice.
Manu Bharwala, Learned Counsel takes notice on behalf of the state and waives for the notice. The trial court records are received, so in the event you get ready with the main matter because you are there in 66. So we'll take up the main matter itself. Your IA, you've not completed 13 years.
Yes, no,
You've
13
completed
years, months.
You've completed, then not with remission. Without remission, you've completed 11 years, 7 months,
Yes, no,
17 days as on 14 January 26.
I have my
So 11 years, 7 months, add another 3-4 months now.
Yes, Lord. And Lord,
So-
Lord, there's
I didn't vote. Mr. Aditya.
Your Lordships, his bail application, if Your Lordship sees page 7 of his bail application, it clearly mentions that he has absconded from parole for 1 year, 2 months, 29 days. Further, he's also an habitual offender there are 4 pending cases against him. There are specific observations made in the impugned order by the Honorable Judge attributing a specific role against him. Now, he may have spent 13 years, he may spend 15 years. It is life imprisonment which has been imposed on him.
These offences are prior to his imprisonment or during the time of parole?
The other FIRs, which were
Other FIRs are prior to his imprisonment.
FIR 227 or 2023. So this is during parole.
Parole.
during the parole.
I not got any parole. Man. No parole.
Your Lordships may have their own annexure, page number 7 of their own annexure, certificate of imprisonment.
In which file? 66 or 66.1?
Your Lordship 66.1.
This is this.
Oh,
You can
that's
see
state.
acquitted.
Because in my application for bail that I filed now, in that I've filed my custody certificate also. Now. In that custody certificate.
Please look at your custody certificate. That also indicates your absconding period.
Yes, Lord, that was during COVID, Lord. They had granted us parole, Lord, and then that
No,
was
not as
So during Your Lordships, during COVID, are they entitled to abscond and that too for such a long time?
No, they did not catch me. I surrendered my.
This was not during COVID.
Yeah.
You were absconding from 19 December 2018.
18 and 19.
When did COVID start?
2020.
March 2020.
2020.
I'm sorry.
So then
You expect us to forget COVID so fast, is it?
My bad, Lord, my bad.
then probably
Then-
we hear it.
Then we'll have to hear.
Your
I'm
conduct-
ready with the main matter.
Your conduct
I'm ready with the main matter also, Lord, if Your Lordships permit me.
in
Based on-
not today.
Because there's another SSP was filed
List
by.
for hearing, you say. List for hearing on 12th August.
Because in this,
Obliged, Your Lordship.
may I just make one more submission? Because another co-accused will also has filed an SLP. Because that also then your lordship will take it up with the main.
No, don't tag on one more matter now. Again, this will get delayed. If it is already listed, then we'll see. That also has defects. Now, this one is already delaying their appeal now. Because their appeal, the trial court records are received because your matter notice is not issued. So this matter will have to go. But we don't know what the other matters.
We don't want to file a counter to their SLP. Because I accept notice in that for respondent number.
Let us see. Let that matter come up.
May I make a small request? Because I had moved for an interim bail on the ground that my mother is not well.
Your Lordship's 53-year-old mother. 53-year-old mother.
Kindly have a look at their counter affidavit. 1 minute.
What is wrong with her at 53?
Your Lordship will kindly.
Your Lordship, the way they are projecting it is my submission that she is the senior citizen who is really in trouble with a chronic disease. Your Lordship.
I am saying your Lordship may not allow that application.
Absconder cannot be.
Your Lordship may not allow my application.
Not a question.
I just want to read their
We
counter.
have hearing matters today, please.
Their counter.
The counsel who are waiting, no more.
No more. Because he's pointing out to my mother's age and he's making an insinuation. I just want to read their counter. In their counter, they
You're not telling us what is wrong with her. What is wrong with her?
Kindly have their counter affidavit.
What is wrong with her? You don't need to go to the counter. Tell us what is wrong with her.
She has dysfunctional uterine bleeding loss and severe.
And what are you going to do about gynecological problems?
There's nobody at home.
Ah.
My father's died. Kindly their own counter affidavit.
No brothers, no sisters, nobody.
Their own counter affidavit they have admitted.
You ought to have thought about that.
May I just read the exact
For absconding at least.
Plus the exact.
Not a case for
Counsel, I think we have told you enough. You've taken enough of our time.
Next, Matt.
Much obliged, Your Lordship.
Yes.
Lord, I am the mother-in-law, and Lord, my husband is said to have stabbed the victim. And Lord, there's
The
nothing.
daughter-in-law's brother you are supposed to have killed.
The daughter-in-law's brother, and there's a specific allegation that Lord, they had come to my.
So the High Court obviously doesn't pay attention to the facts because it describes you as the mother-in-law of the deceased. So the High Court has
that's
picked
the
up
error,
daughter-in-law
Lord.
also.
Yes.
But let the daughter-in-law live. Her brother is the one whom you killed.
Not me, Lord, my husband.
Your husband. Your father-in-law and you together.
Lord, they are including me with a motive of common intention.
Section 3, subsection 5 is also their common intention.
Yes, that is what I'm addressing to you, Lordship. Not a single evidence.
Not a case for
There was a common intention. There was a quarrel.
It shows you also quarreling with that poor boy.
That's what I'm submitting. Just a quarrel may not lead to an intention that I intend to murder him. But the husband has
we don't know whether you exhorted him to.
In the moment of it, he picked up knife and stabbed the guy.
As my brother is saying, don't disown your husband at this age. At this stage.
But my son is also living with you, Lord, and the son has also stated that Lord, it was the father who had stabbed the man.
We find no good ground and reason to interfere.
May I request your Lordship that at least
the High Court, especially petitions accordingly dismissed. Not a case for anticipatory bail.
Lord, one observation that Lord, my regular bail be considered on merit. Lord, it may not come in the way to
say anything. We won't say anything about it.
That
yes.
While considering the regular bail, it may not.
Nothing more comes.
Lord, may I seek, Lord, 1 week's time because it was taken up for mentioning. Lord, it is a APMC. Yes, Lord, I have to file additional documents and seek permission for Lord.
I appear on caveat.
Not an arbitral award. Where's the question of saying it's an arbitral award? There's no invocation.
Lordship,
there's no reference of a claim, no procedure under the Arbitration Act.
Lordship,
how do you say it's an arbitral award?
Lordship may take it, Lord, Monday.
No, Secretary passes
Lord,
it.
Lordship may take it Monday. I will, Lord, because the APMC, Lord, APMC wants to, Lord, engage.
The liberty is given to the respondent to adopt appropriate
all the
remedies.
Lordship may give one permission. I will come out with that, my Lord.
There's nothing there.
Then permit me to.
Where is the invocation of the arbitration?
Correct. There is no section 21 notice, my lords.
Permit me to file 2 documents.
No selective
only
filing
2 documents. No. If your
We
lordship
don't allow filing of documents like this selectively.
No, my lord.
If you put forth your best foot, this is it.
My lord,
Then
it
your
was taken
best
up for
foot is not
mentioning.
deserving.
I'm sorry, my lord. It was for mentioning and not for admission.
No, no,
Therefore,
you filed it. What do you mean? It's for
then
mentioning?
lordship may
You
allow.
find no good ground and reason.
Then lordship may allow.
Grateful.
Passed
Grateful.
by the
Lordship
High
may allow to address.
What else? We are already asked, where is the invocation of the arbitration?
What I'm submitting.
First, show us where is the invocation of
Yes,
arbitration.
for that 2 letters are required. That is
My
of
lords.
2015. What happens? What happens? Allow me to address. Kindly see, my lord.
Show us the letter
My lord,
then.
yes, my lord. Kindly.
Where is the invocation?
13/8/2013. First letter was submitted by them.
Where is it? Show
Stating
us.
the claim.
Show us.
Kindly see.
Lords, they've already filed 2 IAs for additional documents after the filing of this SLP and yet not been able to bring about some new document that they are relying upon now. And the reasoning of the High Court is very sound. Paragraph 4 onwards, my lord,
Kindly
just
see,
says
my lord,
completely
I will-
misguided.
From kindly see page, my lord. Page 4, my lord. Para 3 and 4, only 2 paras of High Court I will point out from that. And then we'll come to the your lordship's, my lord, query.
Yes.
Kindly see, my lord, page High Court order. Yes. Page 2, my lord. Page 2, my lord. That is running page 40 of SLP. Lordship got it.
Yes.
Yes, my lord. The 2 conditions. He has 1/1/2008. He has signed contract wherein there are 2 clauses. First clause 44.
What did
Any
we ask
dispute
you
arising
for,
out of-
counsel?
I'm sorry.
We asked you for the letter whereby
Yes, my lord.
you
My lord,
say
there are
that he
what
invoked
happened. I'm submitting.
Show us the letter, please.
Show me 5/2/2005. Page 191 and 193.
191.
191 and 193.
Appeal filed by us regarding the amount.
My lord,
Where does he invoke
may-
the arbitration clause?
may I submit, my lord? May I submit, my lord?
There is a
2000
specific arbitration clause
Yes,
that
my
is
lord.
57.
My lord, may kindly see they challenged.
Where is the invocation?
Yes, that is what these 2
Nothing.
letters are
Do
required.
you
And
want
one-
to read
one more.
something between the lines and say their appeal against a decision
Kindly
is an
permit me-
invocation?
Kindly permit me 3 facts to be submitted.
Nothing more.
First,
I think we've heard you long enough.
My lord,
The very
Grateful.
fact that you're beating around the bush when we ask
No,
for a
kindly
straight
straight
answer
way I
is
am coming.
enough.
Straight way I am coming. My lord, the jurisdiction of my lord, the secretary was challenged by them before the director of marketing.
In any
2000
event,
kindly see, in 2014, the director of marketing rejected that. Thereafter, they surrendered the jurisdiction. They filed 3 applications, and they
and
say
no
that
ground and reason
to decide.
to interfere with the improved judgment passed by the High Court, especially petitions accordingly dismissed.
Grateful.
Yes.
May it please, your lordships. The
Yeah.
petitioner herein is the owner of a land, your lordships. The preliminary notification is of 2003. Until today, no possession has been taken, no award has been passed, no compensation that's been paid. In fact, now the only reason as to why the High Court has not entertained my petition is for the primary fact that saying that the issues attained finality up to the Supreme Court. My lordships may have a look at the judgment which has been passed by Justice Ravindran, which came up to the Supreme Court. Paragraph number 160, your lordships.
One moment. Yes. Which page?
Page 160 of the judgment, your lordship. Before that, in fact, if I can be actually permitted to actually, upload, the sketch that is there, which shows that mine is the only piece of land, that is 15 guntas that is there, where, the lands abetting my land across have all been denotified.
There's no denying the fact that after the revised notification came,
Please, your lordship.
the final notification dated 23/2/2004 which was for an extent of 2,750 acres. That included your land also.
Please, Your Lordships.
You challenged that acquisition, succeeded before the single judge, lost before the division bench in appeal. Division bench set it aside, set the single judge's order aside on 25/11/2005, restored the acquisition, and your appeals to the Supreme Court 5/5/2010. The Supreme Court confirmed the acquisition, but
Please, Your Lordship.
imposed certain conditions.
One important thing in that judgment of the Supreme Court, my Lordships may have
Those
160.
conditions, with those conditions again, thereafter, when you went 27/9/2021, the High Court directed constitution of a committee to examine your claims with regard to those conditions being complied with.
Please, Your Lordships.
2013. No, 2014, I think.
Two important things. Your Lordships may have a look at that judgment itself. That's 2010 7 SAC 129, page number.
Then thereafter, when your representation to the commission is rejected on 23rd September 2025, saying that there is no construction on the land as claimed by you, as on the date of the acquisition notification, you file a writ petition not only against the committee's report dated 23/9/2025. You want to challenge the earlier notifications, 3rd February 2003 and 18/6/2014. That was obviously overreaching it, because all those are already over.
My Lordships may have para 160. My Lordships may have a look at the judgment. Only two documents that I will actually place before your Lordships. One is the sketch if can be allowed to be actually
No, we are
by
not
the
going
court
to
officer.
look at documents post. If it wasn't part of the record before the High Court, we are not looking at it.
No, just to show your Lordships. In fact, the land.
Which paragraph?
My Lordship, paragraph number 160 of the judgment 2010 7 SAC 129. That is the judgment which actually attained finality in the same round of litigation itself. My Lordships may have a look at the observations made. I fall under that. I'm primarily covered under that.
Para 160.
160, your Lordships. That's the conclusion that is there.
Yes.
In fact, my land is only 15 guntas, of which land which is abutting my land, all of them have been denotified. My Lordships may have a look at this. Which the court also observes that it can't be that that you can create a mini island that is there.
Which paragraph?
My Lordships, it's 160 itself. Both paragraph number 1 and 2, your Lordships. In regard to the acquisitions of Kempapura, Srirampura, is that
the objections to the acquisitions? The large areas are not notified more than 50%.
Whether the deletion to the large extent, whether development in respect of the balance acquired land has become logical and impractical. And if so, whether the balance also should be deleted.
That is the reason why you went before the committee.
My Lordships may read the next paragraph, which is there. Chalakeri, which I'm covered, where my land is.
That is exactly why you went before the committee, is it not? With your representation that you are covered by this. Committee holds against you.
My Lordships, very interesting to note. In fact, my NA conversion was much prior to the foreign notification itself. Now, a land which is abetting my land, in fact, now
the committee's record the findings according to the High Court, they are fair. Proper reasoning has been given.
What more? Even as on date, possession is not taken over, award is not passed, compensation has not been paid. The very purpose of acquisition itself
High Court
is lost.
has said that you are entitled to cash.
My Lordships, that 60/40 doesn't serve a purpose.
And if you are entitled to.
My Lordships, demolishing my house and giving me 40% of it doesn't make sense.
There's no construction as on the date of the notification. That's the finding.
My Lordships, in fact, the finding is
thereafter, after the acquisition.
3 months later, your Lordships, but my NA conversion was much prior to the foreign notification itself.
You are held entitled either for compensation or development.
60/40, your Lordships.
Develop land under the 60/40 scheme.
My Lordships may appreciate it's a small chunk of land that is there. I've actually developed it around 23 years back itself. The land has been developed. At least on grounds of parity, your Lordships, lands which are abetting my
judgment passed by the High Court, especially petitions accordingly dismissed.
But in this case, a tender was invited by the respondent number 2 I applied for the tender.
One
The
moment.
tender was
One moment, Mr. Tiwari. No, this is that bank guarantee or
bank
deposit.
guarantee and EMD, my lord. My lord, there are 2-3 more facts which I would like to point out to my lord. Tender was invited on 22nd of January 2025, and it was for construction of my lord, 11/8/2025 for construction of head work at Lamti Feeder Minor.
11/8/25.
11/8/2025. Lord, the online submission of bids happened on 18/8. Then on 10/9/2025. On 10/9/2025, my lord, the tender committee opened the envelope and said that since we have submitted EMD there and not the bank draft, therefore our tender should be rejected. Bid should be rejected. On 10/9 itself, I submitted an explanation pointing out various provision, including 2.15 of the tender document, my lord. That explanation was accepted by the committee. And Lord, may kindly see that tender committees at page 149. The translated version starts at 148 at 149.
$149.
148 it starts, my lord. Proceedings.
Yes.
148 bottom, Lord, may see RR Construction Limited is the heading of that consideration, and 149, my lord. Lord, the third last paragraph, therefore on the basis.
Yes.
Lord, the tender committee then accepted, therefore on the basis of reading of clause 2.13b and clause 2.15 of tender volume, the representation submitted by tenderer RR Construction and Infrastructure A class contractor for system tender is accepted. Accordingly, tenderer is declared qualified in the said tender. Lord, so I was declared qualified. On this, the respondent number 1, who was a competitive bidder, he filed a writ petition before the Honorable High Court. Now, High Court on construction of clause 2.13 and 2.15 said that a person who is from outside the state of Chhattisgarh is not entitled to submit EMD in this form. And Lord, he also did not submit. That's another aspect, Lord. But in any event, the state supported my case. The state supported my case before the Honorable High Court, pointing out.
And they rely on a judgment.
That are not working.
Yes, Lord, the clause was may submit. So the state was of the view that it is a discretion which is vested in the accepting authority to enlarge the scope of consideration of tender. They accepted my tender and they supported my case. The Honorable High Court held that no, it is like changing the tender condition midway and therefore it cannot be permitted, and set aside that order of the committee and declared me disqualified, pursuant to which then all tenders were opened. Now, when all tenders were opened, my lord, 2-3 very interesting factors which has appeared. My bid is for 120 crore for the work, approximately 120 crore. Whereas the bid amount of the R1 is 149 crore, my lord. 25% more than me. I am 21% less than them, but they are 25% more than me. One more thing happened in between. This on 26th of December, the state now says that I am disqualified because I have not submitted one document which is pre-qualification bid. Now they disqualify me on a second count. Lord, so
why did they have an occasion to again disqualify?
Yes, Lord, they say since we opened the entire tender process, we looked at the documents again and we found that this document is missing. Very suspicious circumstance, Lord.
So why did they have to consider you again?
After you were
Disqualified
disqualified already.
for them to consider me.
Because DB has already disqualified
Said that you are not eligible. So the only question which was limited was whether this EMD could have been accepted or whether bank draft has to be submitted or FDR has to be given. And FDR is also not in my name, my lord. FDR is in the name of executive engineer I have submitted. No, he is inside the state. Very strange method of since 30.
Ground of disqualification we can't go into.
My lord may not go, but my request, humble submission would be, because my instruction are that they have submitted a representation about the second disqualification. But first disqualification